All right, so I'll ask for the second case, which is Save the Davis Meeker Garry Appellant versus Debbie Sullivan, Respondent. Are we hearing it all from amicus today?
I don't believe so, Your Honor.
Okay. And how much time are you reserving for rebuttal?
5 minutes, Your Honor.
All right, counsel, go ahead and begin when you're ready.
Thank you, Your Honor. My name is Brian Telligent. I'm counsel for the plaintiff, Save the Davis Meeker Garry Oak. With me at counsel table is my co-counsel, Rhonda Larson-Kramer. There are 3 rulings that we would urge the court to make in this case. The first ruling is that the historic Davis Meeker Oak is a protected historic resource on the city's historic register, protected by the city's Historic Protection Ordinance, which means that any alteration to the tree, cutting it down, needs to be processed and gain the approval of the city's Historic Preservation Commission. That's the first ruling we would like you to make. The second ruling we would like you to make is that citizens have a right to come into court to seek a restraining order or to seek an injunction for violations of Washington's Archaeological Sites and Resources Act, the archaeological law that applies to archaeological resources, that protects them, that citizens can come in and enforce that law to restrain violations, to prevent the destruction of archaeological resources. And the third ruling that we would like you to make is to reverse the trial court in the trial court's ruling that this tree is sort of absolutely not protected by the archaeological resources law. That was an improvident ruling. It's not consistent with the facts. We need that ruling reversed.
Counsel, can I direct you to the second argument you just made? Is the mayor arguing that you did not have the right to pursue this action, or simply arguing that the dissolving of the TRO is appropriate?
My understanding of the mayor's argument is first, one of the arguments is that they claim that the private citizens do not have a cause of action to come into court to restrain or to enforce the archaeological law at the state level. That is one of their arguments.
The RCW 2753.
RCW 2753.
That was the amicus argument, not the mayor's argument, correct?
The mayor has made that argument in the response brief. And our counter argument to that, Your Honor, is that we came in asking for declaratory relief under the Declaratory Judgments Act. RCW, I believe RCW 724, sorry about that. RCW 724 is the Uniform Declaratory Judgments Act. We asked for relief under that statute. That statute itself provides a cause of action whenever a person's rights, status, or other legal relations are affected by a statute. And the Washington Supreme Court has said that no additional private right of action is necessary for parties to come in and seek declaratory relief, that is provided expressly by the UDJA. And you can find that in Nelson Vos versus Appleway Chevrolet. That's at 160 Wash 2nd, 173. The Washington Supreme Court said, of course, you don't need another cause of action because the Declaratory Judgments Action provides its own cause of action. And the test for determining whether or not you can bring an action is whether the interests you're seeking to protect are within the zone of interest of the statute. Here we are seeking to protect an archaeological resource that's obviously within the zone of interest of the statute. We have a right to be in court and to restrain these violations.
Counsel, before we get too far down the road on this, and at the risk of throwing you off your presentation,
Fair enough.
I'd like to discuss or hear from you, since I'm going to ask the other side. CR 65 requires certain things be done in order to obtain a no-notice temporary restraining order. And it appears from the record, and perhaps I've missed something, but it appears from the record that several of those were not done in this case. And if that's true, if that's true, can't this court resolve this case on that issue alone, concluding that the TRO shouldn't have issued, should be dissolved for procedural reasons, and not reach the other historical municipal ordinances and statute?
I understand your question, Your Honor.
Okay.
And so my understanding is that there are sort of 2 principal arguments for what we allegedly did not do. One was provide notice, and one was we imposed a bond. Mm-hmm. There are also discussions of there not being a description of why the TRO was issued in the first place.
Yeah, there's quite a bit. 65B, CR 65B has a whole bunch of stuff if you're going to go into court and not give notice to the other party. I know there's a phone call, but there were, you want me to read? I don't want to read it.
No,
Take
I
time.
think our global argument is that those issues are effectively moot. The TRO was issued, but then we had a hearing. Well, the hearing ended up being 4 judicial days later. We received notice of that hearing 3 judicial days before it occurred. But at that hearing, the parties had a full and fair opportunity to dispute this TRO, to talk about it, and we had moved to extend that TRO. And at the hearing, we had asked for that to be converted into a preliminary injunction. So whatever issues there might have been with the initial issuance of the TRO in a true emergency situation where we only found out the night before, we had to file this complaint. Whatever issues there was a full opportunity to air and to talk about why this TRO needed to be in place, and we had asked to extend it and asked to convert that to a PI motion. So I think any of those issues are frankly moot at this point after there was an actual hearing on whether this TRO should be granted. So going back, if I may, Your Honor, I had already addressed, I'm not going to say more about it. This argument, we don't have a cause of action, it's just wrong. We have a cause of action, it's called the Uniform Declaratory Judgment Act. The second ruling that we'd like you to make is that this is a protected city historic resource that is listed on the city's historic register. And the city's own code, their own code says, for all properties, not structures, not buildings, not edifices, properties on the historical register, you can't alter them or demolish them or do anything to them without going to the local city's Historic Preservation and Protection Commission. That's the agency within the city in charge of determining whether these resources can be modified or destroyed. And the mayor didn't do that. The mayor still doesn't say he has to do that. She still contests that this tree is even protected under the city's ordinance on the theory that it's not a building, and that's just wrong. It's just wrong under the plain language of the ordinance. It's wrong under the Historic Preservation Ordinance. It is also wrong under the city's tree ordinance. They have an ordinance about just cutting all sorts of trees, right? You need a tree removal permit to take out all number and manner of trees. They've cited that ordinance to you as why they can take this tree down. But that ordinance also says that if the tree is on the historic register, you can't do it unless you go to the commission. So there are just really no two ways about it. The mayor can't cut the tree without going to the commission. And we need guidance from this court because this tree is going to hopefully live for another 400 years. And we need to know who needs to make the decisions.
So the ordinance refers to property on the list.
Yes.
How do you define property? Is tree property?
Yeah, I think the best evidence of that is the city's own actions in putting this tree on the historic register. Because there is the Historic Preservation Ordinance, which establishes the register and says that the city will put properties that it wants to protect on this register, and that is what the city did. So the city's own actions helped define what that means, and then the city put it in the tree code too, and said that if a tree is on the register, you need to go to the commission to get a certificate of appropriateness before you cut it. So there really is no dispute. The third issue is that the trial court ruled that that RCW 2753, the state archaeological law, does not apply to this tree, again because she found that the tree was not a man-made structure. And we had, just before that hearing, the State Department of Archaeology and Historic Preservation had issued a letter. This is the agency in our state charged with identifying these resources, protecting these resources, and had issued a formal letter to the city saying, this tree is an archaeological resource, it is protected, you need to get a permit before you alter or damage or destroy this tree. And the city still came into court saying, we're cutting the tree down next Monday. And our argument to you is that ruling by the trial court that the archaeological law does not apply, it gave no credence to what the state agency has said, and it gave no credence, frankly, to what the law itself says. And I would just like to read to you very quickly. I think one of the most important parts of the statute is if you look at RCW 2753040, we discussed this in our briefing. This is the state declaration of what is an archaeological resource under this law. And that provision says, and this is specifically with respect to properties that are on public land, including city land, right? So it's not just your grandma with a tree in her backyard, but city land, it says all sites, objects, structures, artifacts, implements, and locations of prehistorical or archaeological interests are hereby declared to be archaeological resources. And then it defines prehistoric to mean concerning knowledge of cultures that we don't glean by contemporaneous written documents. This tree was a trail marker on an ancient indigenous trade route. It was culturally cultivated. It's not just a natural tree. There's evidence in the record that the ancient indigenous practice was to burn the prairies, get rid of the other plants, specifically so that these kinds of trees could live. This tree is a remnant. I'll take a little of my time if I could. This tree is a remnant of that practice. It is a remnant of that practice of cultivating this tree, which still stands today. It is an archaeological resource, and this court needs to reverse the trial court and say no. There is still much to be learned from this tree. It is improvident to say that this tree cannot be an archaeological resource. Thank you.
Thank you, counsel.
Good morning. May it please the court. My name is Jeff Myers. I represent Mayor Sullivan in the city of Tumwater in this matter. Respectfully, the issue that is before the court today is whether the trial court abused its discretion in dissolving an ex parte TRO issued in violation of CR 65 and statutory requirements for issuance of a TRO without notice. Judge Egler did not abuse her discretion, and the ex parte TRO was properly dissolved.
She didn't dissolve it on procedural grounds, though. She made substantive rulings. They're pretty bare bones, what the court outlined, but those procedural arguments were not part of it.
I think that the trial court's reasoning on this was both substantive. I also think she recognized that the process was improper. For example, in the determination with regard to RCW 2753, you will not find in the complaint filed in this case any reference to RCW 2753. It simply isn't there. It was not a basis for the issuance of the TRO. It was not a basis for the motion to extend the TRO.
Sure, but she found it didn't apply on its merits. She notes that it was raised in a tardy fashion, but she says she took a quick look at that statute and reveals that the chapter of the law addresses archaeological resources, not trees. Therefore, that is not applicable. That isn't. So these procedural arguments you're making, that's not what she relied on.
It is an observation about a quick glance at a letter and a statute that had been provided the day before, after recognizing that it was not properly briefed. There was no opportunity provided to the city to brief the matter, but just a quick glance at the statute was that it deals with archaeological objects, not trees. Whether that is correct or not is not an issue, I think, before the court today, because 2753 was never raised properly in the trial court.
So wouldn't the appropriate remedy be for us to remand to have the trial court properly, if you're alleging the trial court didn't actually consider it on its substance, to remand, have the trial court consider that statute in light of amicus's position that it does require a permit?
Well, first of all, amici are not to raise new issues on appeal. So even if you get past that practical purpose, remand to the trial court is the appropriate outcome of this for a variety of different reasons. But in remanding it, you should affirm the judge's decision to vacate the TRO because it was improperly issued for numerous reasons. There was no written motion ever asking for the TRO, explaining to Judge Amamillo, the ex parte judge, what was being asked of her, to explain what the standards she needed to apply. There were no findings made in the TRO itself of, is there irreparable harm? What interest of the plaintiffs was being protected? There are no findings why it was granted without notice.
Aren't two of those things a bit self-evident, though? I mean, the irreparable harm, once the tree's cut, it's cut. So it's not really debatable what the irreparable harm would be.
But CR 65 requires that there be a motion and findings as to what that irreparable harm was. Judge Amamillo never made any findings, and the order that counsel drafted that she simply autographed doesn't have any findings to that effect. And do we have a motion to go to figure out what was being asked of her? We don't even have a motion. And this goes to the due process nature of what was being done here. The lack of adequacy of notice. Counsel's declaration only recited only that there was a voicemail left. And this was a voicemail provided 29 minutes before counsel ran off to court. There is no explanation, no certification in writing for the reasons supporting their claim that the notice requirement should be dispensed with. There's no showing that they could not make more efforts or that they could have notified the city earlier. So Judge Amamillo did not make any findings as required by CR 65. And this is precisely the facts of the Fowler case. Department of Labor Industries versus Fowler. Department of Labor and Industries ran off to court to get a temporary restraining order to enforce COVID-19 restrictions about operation of a restaurant. They did so based on a phone call that was made 3 hours before to an employee of the restaurant. And they actually emailed the pleadings to a general email account. So they actually did more in terms of notice than what was done in this case. What the declaration that the Assistant Attorney General filed in that case failed to do was to explain the reasons why notice should not be required. And this court held, in opinion Judge Veljacek authored, Judge Maxa joined in, what they held was that this failure was particularly troubling and was precisely the abuse that CR 65B intends to prevent. And so the court held that that violated due process and was issued without authority, and therefore the TRO was void. And this followed the Smaldino case in doing that. Now, in terms of the other defects here, the defect of failing to identify a hearing to have a preliminary injunction considered is absolutely fatal to the TRO. The language of CR 65 expressly states that if you do not include such a hearing, that the TRO shall be vacated. So CR 65B expressly requires that hearing. It was not included in the TRO. And that is another reason why the Judge Egler was correct in vacating the TRO.
You're arguing that even though she didn't rule on that basis, that we can affirm on any grounds, so we can go behind the trial court's ruling and look at the issuance of the TRO.
Precisely, Your Honor. And that was the primary basis of our motion to vacate the TRO.
And counsel, wouldn't we be right back here on the municipal code issues after that? And so I guess more directly, shouldn't we address these issues regarding the historical significance of the tree, the protection to the tree under 2.4?
No, you shouldn't, because of the procedural posture of this case. This case is here after a TRO hearing that is based on very little fact-finding. There are no findings of fact in either of the orders.
I mean, these are legal questions, though, right? Like in terms of what the mayor's required to do before removing, destroying a tree, that is listed as a historical place on.
Well, there
Tumwater's
are
website.
legal questions and there are also factual questions. For example, counsel has averred that there is evidence in the record that the tree was cultivated, that they burned the prairies. None of that is in the record before the trial court.
And again, but just this issue of what the mayor in that particular municipal structure is required to do before remediating in really any way this tree. That's a purely legal question.
And those legal questions are not necessarily, you don't need to decide those for a couple of different reasons. One is that, as counsel acknowledged, the mayor has decided to get a second opinion and get more information. This was all done after Judge Igler's decision. And she exercised her discretion to get more information. And the city is going to proceed with pruning of the tree. And the plaintiffs have claimed that that kind of maintenance is not required. But you don't have a factual record about that. Those are things that are best left to the trial court to figure out.
In a hearing de novo on the TRO? In a de novo hearing on the TRO is what you're saying?
A de
Because
novo
earlier you
hearing
said
on-
you want us to affirm, but now what I hear you saying is that we need to have a de novo hearing on whether the TRO should remain or be dissolved.
Well, not a de novo hearing on that TRO. That TRO was properly dissolved. The case comes up to you in an interlocutory fashion. There's no final judgment here.
The only thing before us is whether the trial court properly dissolved the TRO. So our remedy is either going to be say, yes, the trial court properly dissolved the TRO, and then you all walk away from our court and there's no TRO and there's nothing preventing the mayor from cutting it down in the next 12 hours after our ruling. Or we say, well, the trial court erred in this respect or that respect, and there needs to be either further fact-finding or on a new TRO hearing addressing this, that, or the other.
And,
Right.
and if you send it back and affirm the dissolution of the TRO, one, the city has already adopted a program, which was the subject of our motion to dismiss because it's moot, to proceed with maintenance of the tree.
Right, but that's not,
But
we don't know that. There's nothing alerting us that
there wouldn't be a legal prohibition at that point in time. You could remand it and have a new hearing on a TRO. They are not precluded from raising an additional motion to the trial court, which is where these facts ought to be adjudicated, not in an appellate court, which is not set up to take evidence or have hearings about what the facts are. And the question here of what repairs are necessary, what emergency measures are necessary, the city's ordinance, and council didn't address this, the city's ordinance allows emergency measures to be taken by the city without seeking approval of the Historic Commission. It allows a removal of heritage trees without a permit to do so because they are determined to be hazards. And our position...
The definition of emergency is to maintain the tree, not to cut down the tree, right?
The definition of emergency is a threat to public safety. And I think you have to interpret the emergency measures language as being those repairs or those measures that are necessary to safeguard the public, because that's the core mission that the mayor has and that city government has, is to protect public safety and to prevent a tree from dropping its limbs on the neighboring property where it could injure workers at the hangar, or where it could drop those limbs, as it has already done on multiple occasions, drop those limbs on a busy highway
and
Isn't the
possibly
claim of
killed you.
emergency somewhat undercut a little bit by the length of the time it took to bring up this appeal, addressing a TRO? Couldn't the mayor during this time have simply gone through the procedures that are outlined, gotten the certificate of appropriateness, gotten a permit under 2753? I mean, the mayor could have done those things in the interim, correct? It undercuts the idea of there being an imminent nature emergency, that this tree is going to fall over on a car at any minute, right?
In order to even figure out what the nature of things were, the Department of Archaeology and Historic Preservation told us we had to get a permit to simply look at the condition of the tree. If that tree had fallen over, we'd be suing the Department for delaying us from protecting the public. And that's the emergency is protecting public safety. And I think that's how you have to interpret things. With regard to whether or not it's an archaeological object, the definition that Mr. Telligin just read to you refers back to of an archaeological nature. And that is things that evidence human activity, human remains. The definition lists a variety of those things, and they're all man-made. Now, whether or not this tree is a man-made object, I think is pretty clear. The tree is not, it's a tree. It's an old tree, it's a nice tree. But the city's duty is to protect public safety. And you should interpret, as Judge Egler did, the law in a way that allows the city to do that. You should affirm her dissolution of the TRO and remand the matter back to the trial court. Thank you.
Thank you, counsel.
Thank you. I'd like to just start real quick by reading something from the record that was submitted to the trial court with the initial pleadings in this case. Very first thing that was filed is a declaration by Bill Isle. He's the chairman of the Cowlitz tribe. He says, "The Meeker oak is a fixture in our community. The basis for those trees derives from an ancient practice of regular burning of the prairies that limited the growth of the fir and allowed the survival of the oak. The original Cowlitz Prairie extended from Vancouver to Puget Sound. When the settlers first came, they were blown away by the verdant prairies. The green expanse and the oaks were remarkable. The Meeker oak is a remnant of that." Very first pleading in the case, one of them, with the complaint. So no, it's in the record. This tree was cultivated. It was cultivated by ancient peoples, by indigenous peoples, and it's within the memory of the tribal Native Americans that are still here today and who value this tree.
Counsel, why isn't your easiest argument that the ordinance, the dual ordinances that appear to refer to each other in the Tumwater Municipal Code, isn't that your easiest argument, that they would require the mayor to go through the committee and get this certificate?
No doubt, Your Honor. So I'm reading this because counsel just said this wasn't in the record, that it's a cultivated tree.
Okay.
He doesn't know the record. It's in the record, first thing filed, okay? But yeah, it's a knockdown, drag it out argument. The code says any property on the register needs to go through the commission, and it says it twice. It says it in the Historic Preservation Ordinance, and it says it in the tree code.
And I'll just address it. We could keep it above board and not
I'm
point
sorry,
at counsel.
I apologize. I should not, I got it animated. But yes, it is my easiest argument. It's not just my easiest, it's an objectively easy argument because it is true. It is true and clear to the language of the law. With regard to procedure, Judge Egler did not find there was any procedural irregularities. And Judge Egler, I believe, found that or went past those because she understood that the hearing that occurred on May 31st, that was the opportunity for the parties to dispute whether this tree should be at least saved for a little while people figure out whether or not there's really an exigent circumstance or what should happen to it, or whether it should be cut down the next Monday after a Friday hearing, because that's what the mayor's council told the judge. When the judge asked him, what's going to happen to this tree if I dissolve this TRO, he said, we're going to mobilize, we're going to cut it down early next week. So we went into court because we believed that this tree was going to be cut down the weekend, Memorial Day weekend. We had to get into court quick. This had to happen. And there was no procedural irregularity because the parties had a full opportunity at the May 31st hearing. Regarding whether this issue of the state law being adequately raised, I think what happened was the judge was thinking about CR 15B. The CR 15B says that when issues are raised that go beyond the pleadings and they are objected to, then the judge can still entertain them and allow the pleadings to be amended. The pleadings weren't formally amended, but she went on to rule on the merits. She didn't, and I think the prudent thing would have been, frankly, is to say, let's put a pause on this situation. The state agency in charge of these things has just entered and said this tree is a protected resource. Let's not dissolve the TRO right this minute, but let's figure it out. But she did do us the decency of ruling on that the merits of that, which I think is consistent with CR 15B, but she got it wrong. Because the statute does not say it's limited to even to man-made objects. It says specifically also prehistorical. And this was a cultivated tree. Now, there are lots of other, knowledge is emerging about this tree. There are other declarations we filed in support of our motion for an injunction before this court, where we went into the fact that it was a trail marker. It could have been culturally modified, because often the indigenous peoples had direction markers, and they would modify the trees to point in certain directions. It could be a burial marker. There is a wealth of information to learn about this tree and to figure it out. But the little we do know, and the little that's in the record before the trial court, shows that it was cultivated. It was cultivated. It fits the description of the remains of human activity. Now, we will be here again because we're getting mixed messages. The mayor says she's not going to cut it down, but nothing restrains her. And she has been arguing to you in this court that this tree needs to be cut down. And we would like clarity. And thank you very much.
Thank you, counsel. Thank you, counsel. And with that, we are going to take a brief recess to reconstitute the panel for our third case. And we'll be back in a few moments.
All rise. Court is at recess.